Hi, this is Laverne Lyles, and am going to explain property law. My first slide is a copy of a deed, and this deed goes back to 1868, which is quite interesting. And the name of the person on it is Daniel Furman. Furman, it looks like. But I chose this because it was so old, because now it's 2018. Then now I want to discuss the land transaction. Land transaction includes the purchase and sale of real estate. This includes both the land contract, which is step one, the closing, which is step two, and I will also be mentioning the recording. The land contract is a form of seller financing. It is similar to a mortgage, but rather than borrow money from the lender or bank to buy real estate, the buyer makes payments to the real estate owner or seller until the purchase price is paid in full. There's a noticeable gap between the contract being signed and the closing. But the reason for this gap is so that it gives the buyer time to obtain financing, allows them to retain a researcher whose job it is to search to see if there's any liens against the property or to determine if the property does in fact belong to the seller. All of the necessary inspections of the property is also done at this time. Then there's the closing. The closing is where the deed becomes the operative document. The closing is where the seller passes the legal title um, to the buyer. Under land contract, there is an agreement between the buyer and the seller pertaining to a specific tract of land. It must be in writing. The land contract allows the buyer of the property to use it while the seller continues to retain the deed. Once the buyer pays the full price specified in the contract, the seller gives him the deed to the property. Land contract must be signed by the party to be bound, describing the land and reciting some consideration. There is one exception to the statute of fraud, and it is part performance when it comes to property. Part performance is an equitable principle that allows and enforce an oral contract despite its legal deficiencies. By applying the part performance doctrine, a party can establish the existence of a contract despite the lack of any written evidence. Generally, without written evidence, a contract does not satisfy the formal requirement set by the legislature under the statute of fraud. This doctrine allows failure to comply with the statute of fraud to be overcome by a party's execution. Okay, when there's a statute, um, when there's a when there's an issue with a property, any two of the following three circumstances sort of satisfies part performance. The buyer takes physical possession of the land, or the buyer pays all or a substantial part of the purchase price, or the buyer makes substantial improvement. Any two of these will satisfy the part performance doctrine. So it's sometimes, even though we don't have something in writing, if any two of these three occur, the judge or the courts will grant to the buyer that property. There is also another issue, and this is actually the problem of risk of loss. This I found rather interesting because when, from the time the buyer signs a contract saying that he's interested in the property, before he signs again for the closing, anything may happen on that property, any sort of damages, such as floods or earthquakes, and you're not sure where the property is situated, and you don't know, you're not familiar with the area, so you're assuming that what you're buying is an A1 shape. But if there's a flooding during that time between your signing of the contract to the signing of the closing, the buyer is responsible for any of the damages, unless, of course, there is a writing in the contract to state that the seller will be responsible. Okay, now we're going to talk about marketable title. Marketable title is it's saying to it's telling the buyer that the property that you're getting, I can sell it to you as the seller. And since I can sell it to you, it's saying that no one else is going to come after you and saying that that property is not is not mine. No one's going to come after you and say that they have any liens against that property. That's when that is what marketable title is. There are two different, the marketable title and there's insurable title. Insurable title is meaningless. It just means that the property can be insured. But marketable title is better because it means that no one else can come after you for this property because it does in fact belong to the seller. There are three circumstances which will render the title unmarketable. One is adverse possession. An adverse possession is if there's a property that is sitting and no one is living in it. If someone walks by that and they decide, oh, I'm gonna move into this property, and they move into that and they start fixing it up, excuse me, and they start fixing up the property, the government will, in fact, excuse me, the government will in fact give them that property through adverse possession. Another circumstance is encumbrances. That is any claim against the property, any limitations against the property, any liability against the property is called an encumbrance. An encumbrance includes the liens, the deed restrictions, the easements, the encroachments, and licenses. So an encumbrance will restrict the owner ability to transfer title of property to another person. The other, the other, the other circumstance is zoning violation, and zoning violation. This is these are codes where the government says, or the city, the state, or the right. They say that in this area it can only be residential homes, but in fact you build an industrial building. That's a zoning violation. Or in fact, you say downtown you can only have um, homes that are 1 story, and you build a 4 story. Those are zoning violations. Those are things that the city or the state says that they cannot have. And when you do that, those are zoning violations. So those are the three circumstances that will render the title unmarketable: adverse possession, encumbrances, and zoning violation. Next, this is the seller's duty to disclose. The seller of real property has a duty to disclose any known defects that materially affect the value of the property. And this goes back to what I mentioned earlier about if on that property there it floods, you have to mention to the buyer that during the rainy season, this property will flood. Or we've had known things where sewage comes from other areas and it affects the area. But you must disclose anything that the buyer deems material. And so that's really what it is. Any of those things are actually material. They are considered material. Next, this is the closing. The closing, where the deed becomes the operative legal document. The deed passes legal title from seller to buyer, and the deed must be lawfully executed and delivered. The deed has to be in writing, signed by the seller, lawfully executed in accordance with the given jurisdiction formal statutory requirement. Standard for delivery is a legal standard, not a literal one. We think delivery means something from one place to the next. That's not what delivery of the deed means. It means that did seller have the present intent to be immediately bound? And did buyer also, yes, yes, also, right. And whether the buyer meant to be legally bound to take over the property. So that's what delivery means. Delivery doesn't is not a physical thing. So the seller must have the legal ability to grant the thing or privilege, and the buyer must have the legal capacity to receive it. It must be executed by the seller in the presence of the prescribed number of witnesses. This is all the this is I'm continuing with the closing. Okay. A deed conveying real estate takes effect and transfer ownership to the named grantee when the deed is delivered. The mere signing of the deed by the owner as the grantor is not enough to divest the owner to his title to an interest in the real estate. Delivery of the signed deed is required, and delivery refers to two separate acts: the grantor's intent to convey title, the grantee's acceptance of the grant deed. While the grantor may intend to convey title when handed over the deed, if the grantee does not accept the deed, it's still not valid. Okay, the grant deed need not be recorded to deliver title to a new owner or to revest title in two or more individuals. Recording perfects the ownership against unknown off-record interests and later buyers or encumbrances. Now we're going to talk about covenants for title. There are three covenants. There's a quitclaim deed, the general warranty deed, and the statutory special warranty deed. The quitclaim deed is a legal instrument that is used to transfer interest in real property. The quitclaim deed is the worst one, which means that nobody's doing any research on it. You don't know whether the property even belongs to that person, and they say, "Oh, I'm going to just pass this on to you." That don't ever do the quitclaim deed. General warranty deed, on the other hand, is a deed which is a type where the seller guarantees that he holds clear title to the property and he has the right to sell it. The statutory special warranty deed is a form of real property conveyance in some states. It is typically an abbreviated form of the warranty deed. It's authorized by a statute that allows a deed in a statutory form to include the standard title covenants found in a warranty deed by implication without the necessity of stating them. The general warranty deed has 6 covenants. It has 3 present covenants and 3 future covenants. The 3 present covenants are the covenant of Sisin, which is the covenant is essentially a covenant that the seller owns the real estate that the deed says it conveys to the buyer. The covenant of right to convey is a promise that the seller has the right to convey the described estate. Then there's the covenant against encumbrances, which is a title covenant in a form of a stipulation by the covenanter that there are no outstanding rights or interests to the real estate conveyed. Then we have the 3 future covenants, which is the quiet enjoyment. It's a covenant that promises that the grantee or the seller is telling that the buyer of the estate will be able to possess the premises in peace without being disturbed by hostile claimants. Okay. Then there's the covenant of warranty, which refers to a covenant that runs with the land. The covenant of warranty is considered as only binding the party to give damages as a compensation for the loss of the land warranted. Then there's the covenant of further assurances. All parties of this agreement shall, upon request, perform any and all acts and execute and deliver any and all certificates, instruments, and other documents that may be necessary or appropriate to carry out any of the terms and conditions and provisions. Then we come to the statutory warranty deed. The seller warrants that this is what the seller warrants in the statutory warranty deal, that at the time of the making of the delivery of the deed, he was lawfully seized of an indefeasible estate in fee simple in and to the premises wherein described, and had good right and full power to convey the same, and also that the same were then free from all encumbrances also, and that he warrants to the buyer and his heirs the quiet and peaceable possession of the premises. Then, now that we've finished with the land contract as far as the signing of it and the covenants and the closing, we come to the recording system. There are three types of recording system. There's the Notice Act, there's the Race Act, and the Race Notice Act. The Notice Act, about half of the states have recording statutes called the Notice Act. It may say something like, no interest in real estate shall be good against subsequent purchases for a valuable consideration and without notice until the same be recorded according to the law. Then the Race Act, only a few states use the Race Act. And what they're saying is, and it'll say something like, no conveyance of an interest in real property shall be valid against a third party until it is recorded according to law. The third one, which is the Race Notice Act, is the most common, and it includes both. And it would say this: every conveyance of real property is void as against any subsequent purchaser or mortgagee of the same property in good faith and for a valuable consideration, whose conveyance is first duly recorded. Here ends my presentation, and we come to the and so my completed land contract, and I will reiterate that a land contract is a written legal contract or agreement used to purchase real estate, such as vacant land, a house, apartment building, or commercial building, or other real property. A land contract is a form of seller financing. A buyer and a seller both sign the land contract, covering agreed upon terms and conditions of the sale. Upon satisfaction of all contract terms and conditions, including payment of the purchase price over a specified time period, the legal title of the property transfers from the seller to the buyer by way of warranty deed or other deed used to convey title. Thank you, and I hope you enjoy this.